Hi, everybody. We're going live on Facebook as well as live on our radio show here in just a second. For those of you who have not watched the show before, just understand that we don't have the technology to connect our live call-in directly. So if we do get live call-ins on the radio program, you won't be able to hear them on Facebook Live. We will try to repeat any questions or comments so that everybody's on board with the whole deal. So here's the opening title music stuff.
You didn't say salvo.
Salvo? Yeah, here we go.
For the Art Latex, Aging Insight is dedicated to helping you navigate the challenges and blessing of growing older. So call in and ask your questions. The number is 903-793-1071. Now here are your hosts, John Ross and Lisa Schulmeyer.
Welcome to Aging Insight, everybody. This is your host, John Ross, here live in the studio with my co-host, the one and only Lisa Schulmeyer.
Yes, good afternoon.
Yeah, so you're listening to the number one radio program related to your health, housing, financial, and legal needs. Aging Insight brought to you by John and Lisa, the king and queen of elder law.
That's right. Yeah, no, the deal is there's so much information out there when you head into retirement, and we want you to know it because, it's complicated. It is so complicated. In today's show, we're certainly going to be talking about a complicated issue, but that's why we have this free program of Aging Insight to arm you with information.
That's right. And of course, we can only do this because of the generosity of our sponsors. So we always like to give all of them a little shout out here on the radio. So special thanks to Directives Hospice, Red River Federal Credit Union, Texarkana Funeral Home, Cowhorn Creek Estates, the Barnett Agency, Edgewood Manor, Nursing and Rehab, Reunion Plaza Nursing and Rehab, and Heritage Plaza.
Yes,
Nursing and Rehab.
Also Texarkana Hospice.
Yes, and Texarkana Hospice, right. our newest sponsor there.
That's right.
So.
And John, the last time we were here live in the studio, well, I was here live in the studio. You weren't here.
No, I was busy.
Yes, but we had Directives Hospice on, and they were talking about their Senior Fun Day. And for those of you that listen to the show, I hope you didn't show up at Spring Lake Park because it was canceled because of the rain.
Right.
But it has been rescheduled. So I want to let everyone know that the Senior Fun Day has been rescheduled, same place out at Spring Lake Park for May 23rd. And John, this is a great day for senior activities.
Sure.
Because on Thursday morning, May 23rd, you can come out to Trinity Church for Eggs and Issues.
That's right.
And you can have a nice breakfast. And I think, John, you'll be speaking.
I will be speaking.
So come out for that. And about the time we get done with Eggs and Issues, about 9:30-ish or so, you can make your way over to Spring Lake Park for Senior Fun Day.
Perfect.
Where they will be having games, booths. I understand the bingo tent is very popular. They'll be having fishing out there. You don't have to bring any fishing gear. They're going to have that for you. They're also going to have lunch, some live entertainment. So you could, the Thursday, May 23rd, if you're a senior in Texarkana, I don't want to hear anything that there's nothing economical or interesting to do.
That's right.
Because that's 2 meals right there. Yeah. Breakfast, lunch, hanging out with friends, making new ones, winning prizes. So anyway, so May 23rd, Eggs and Issues in the morning, Senior Fun Day at Spring Lake Park, sponsored by Directives in the afternoon.
Yeah. So come out to Trinity, come see me on Thursday. And if you just can't get enough of me, which I don't know how you could, really. But on Tuesday, over at Williams Memorial Church over there on Moores Lane, I'll be speaking about veterans benefits for the Area Agency on Aging.
Okay.
So that'll be at about 11:30 over there at Williams. So lots of good opportunities to get some information out there. I did want to say thanks to everybody that came out to the Alzheimer's Alliance Wine Festival last weekend. That was a fantastic event, biggest fundraiser in Texarkana, and supporting my favorite charity, of which I do happen to be the president of. So yeah, great organization, great event, went off without a hitch despite the threat of weather.
Yeah, there was a nice big rainstorm Friday evening, but the Saturday event turned out great.
Turned out really good. So thanks for all of that. Thanks for everybody that came out. And for all of you who are listening live on the radio, just remember that we are also simultaneously live on Facebook. So you can go to the Ross and Schollmeyer Facebook page, check us out live if you would like to see what radio looks like.
That's right. Well, John, last week it was a rerun. We weren't here in the studio. We weren't.
That was the weekend before.
Yeah. But that's because I had told our listeners that we were going to be at the National Academy of Elder Law Attorneys annual meeting, which was held over in Fort Worth, Texas this year.
Yeah, it's in Cowtown.
That's right. So all those folks came down from New York and Massachusetts and over from California, and about 200-300 elder law attorneys met up in Fort Worth, and so we got some information about some things that are going on across the country, and John and I feel very strongly that we need to have that information in our community, and so as we roll on through the next few weeks, we're going to be bringing all of that to you as well. So we try to stay up on it to keep all of you up on everything.
That's right.
And John, I did see, a few weeks ago, we did a show, we talked about Tim Conway.
Yeah, no, that's right. We had done a show about Tim Conway, in particular, the fact that there was a contested guardianship going on. His daughter and his wife had gotten into it over who was going to be making the decisions related to Tim Conway. Tim Conway, known best as the voice of one of the aged superhero characters on SpongeBob SquarePants.
That was it, Barnacle Billy or something like that?
Yeah, Barnacle Boy.
Barnacle Boy, yeah, okay.
On SpongeBob SquarePants.
Yes. And
maybe that's not his best known role.
Probably not.
But it was one of many.
Yes, and so for a lot of our listeners, they certainly remember him from the Carol Burnett show. But sadly, Mr. Tim Conway has passed away at age 85 after a battle with Alzheimer's dementia. And so that guardianship battle is now over. Peace for Mr. Conway, but I suspect there will be little peace for his family.
Yeah, as so many contested guardianships become contested probate cases.
Yes, so we'll see what's going on with that.
As is going on, I believe, with the estate of Tom Petty.
Yes, the estate of Tom Petty is also in a big battle between children and wives and whatnot. So there's always a celebrity case going on, and today, John, we're going to spend the rest of our program really talking about a family out of Beaumont, Texas. So that's some homegrown state folks right there.
Yeah.
They themselves never been in the spotlight before, but this particular family is now in the spotlight, highlighting some of the issues with the Texas Advanced Directives Act provisions, which govern how hospitals and medical providers and families make choices about care for a loved one who appears to be at or near the end of life.
Yeah, no, that's exactly right. And, we've talked about advanced directives, aka living wills, a lot on the show over the years. That's, an advanced directive is one of the 4 fundamental pieces of basically every adult's estate planning. A general durable power of attorney for your business, a medical power of attorney for your medical decisions, a HIPAA release so that you can get access to medical information, and then that living will that talks about your desires related to end of life decisions.
Yeah.
And we've, we talk about these. We encourage everybody to have these sort of things in place. Understand that they are much more complicated documents than what you realize.
Right.
I've got several issues just this week with people who had financial powers of attorney and have been using them to do things that they do not have the power to do.
Right.
And what they don't realize is that there could be some significant penalties, including potentially crimes involved.
Yeah.
Because they're doing things with a document that doesn't give them the authority because they don't understand the documents.
Yes. And so John, you just mentioned that the advance directive or the living will or directive to physicians, really all different names for the same or similar document. That particular document is part of a 4-document set that we often recommend. And a minute ago you said those are the 4 fundamental documents of an estate plan. And of course, I'd like to roll that back and say, we talk often about these documents, durable power of attorney for business, medical power of attorney, HIPAA release, advance directive. John, in the case of all of those documents, the patient, the principal, the person, still breathing.
That's right.
They're still alive. These are living documents in the sense that they inform your family. They provide tools to your caregivers and your loved ones that are there to assist you while you are living and breathing.
Yeah, in fact, the name living will actually originally comes from a law review article from back in the 1960s, where modern medicine was getting to a point where we could maintain somebody's physical life, even if their mental capacity was gone, if there were very little brain function. And this law review article writer said that the only estate planning document we have at our disposal is a will, which only takes effect at death.
That's right. First rule of a will is you got to be dead.
That's exactly right. And so he was proposing the idea of a will for while you're still alive, and it just kind of picked up the name then living will.
Yeah, it's a little confusing, I think.
It is, but that's generally the idea. Is we're talking about having something in writing, but the interesting thing is most people think that if you have gone out and you've taken the time to put your desires into writing, that's what's going to happen.
Right. Yeah, no, they think that. And in a best case scenario, maybe that's true.
Right. And so that's the issue today is, while we sit around and we tell people how important it is to express what you want for you while you're alive, there is, particularly in Texas, and that's what we're going to be talking about today, there's this provision related to essentially, regardless of what you've said or what you want, that being taken away. So as we continue with the show, we're going to talk about the Advance Directives Act, essentially how it reads and the order of who makes decisions, and then we'll kind of get into this particular situation that's going on down in the deep East Texas. So
that's right. Yeah, we're gonna highlight the Jones family today out of Beaumont, Texas, but they are not the only family that has been impacted by the Texas Advance Directives Act, but they're the most recent and in the news family. So we're kind of going to springboard off of their experience to inform you all out there. Because really, John, these type situations could happen to anyone.
That's exactly right. So we'll talk about that when we come back from this break. Stick around. And of course, we're still live on Facebook. We're just taking our radio commercial break, which we have to do a couple of times.
Yeah, we got to pay the bills.
And we have comment here from Mrs. Cook, who I exchanged some messages with earlier. Welcome, Mrs. Cook. And just for everybody's reference, I believe Mrs. Cook is actually the attorney that represents the family that we're going to be talking about today. Very familiar with the state of the laws for everybody. So just as anybody's watching, there you go. And yeah, this is a complicated situation. It's a complicated topic. And as I've always said, particularly when it comes to, in our practice where we deal with a lot of things like dementia, the intersection of law and medicine is a freaking train wreck.
Yeah, no, what seems so black and white in one area of medicine is not black and white in the law, and vice versa. I mean, just the very definition of capacity to make decisions is all over the map, depending if you're asking a lawyer, if you're asking a doctor, John, even if you're asking a psychologist. That's just one example. So the intersection of law and medicine, it's definitely not well defined. And so a lot of these type cases kind of bring out some of the issues that we haven't quite answered yet.
Yeah, no, that's exactly right. And so, yeah, anybody that's watching, feel free, if you've got some questions or comments, feel free to put them in the comments section. And we'll either answer them or probably engage in some discussion with some of the other viewers there. So,
well, and the great thing about Facebook Live is you can go back and watch this program after we get done with it today. It is archived, and you can go back and watch it again. You can also comment and ask questions well after the program has been broadcast, and we'll definitely interact and get you some answers and continue that discussion.
Yep. So we should be going back live on the radio here in about, I think 30 seconds, might be 60.
Yeah. Trying to meld to get, speaking of intersection of computer and technology and radio, which has been around a while.
Yeah, and a couple of lawyers who don't know anything about any of it.
We don't do broadcasting, but yet here we are.
You'd think after, I don't know, 6 years of doing this, we would know a little better.
Yeah. Think.
Well, we haven't been doing the Facebook side of things that long. All right, 10 more seconds. We're going live. Y'all keep watching, and we will be heading in. Here's the intro music.
Have a question? Phone 903-793-1071. Now back to Aging Insight with John and Lisa.
All right, everybody, welcome back to Aging Insight. I'm Lisa Scholmeyer, and I'm here with John Ross, and we are elder law attorneys here in the, I guess you would say the Arklatex area is what we call it, but yet, gosh, we cover the state of Arkansas, the state of Texas, and visit with a lot of folks from all over, really. But this program is designed for just our average listeners out there to get some information about elder law topics. And today, John, we are revisiting the Texas Advanced Directives Act because it has been in the news recently.
Yeah, that's right. And this all basically centers around Carolyn Jones, and this popped up into the news probably in the last maybe 2 weeks or so, or at least that's when I saw it. But Carolyn Jones here, pictured on the left for our Facebook viewers.
Yes, I think that is a lovely photo of the Jones family right there.
Yeah,
she looks like she's having a good time.
Yeah, looked like she's having a good time with her husband there, who's wearing his motorcycle jacket. I understand they were big motorcycle riders, and that Mrs. Jones, that was one of her favorite things to do, was to be out on the bikes.
Sure. Living life.
Yeah, probably something a lot of our listeners can relate to.
Sure. So yeah, I understand that Mrs. Jones, she did have some health issues. I understand that she'd been dealing with some effects from diabetes. Also, not a terribly uncommon circumstance. And that she had a stroke, I believe, in late of 2017, which cascaded into a lot of health issues, hospitalizations, rehabs, just just kind of that wheel, that healthcare wheel that sometimes you can find yourself on.
Yeah, we see this with a lot of our clients where, you have this hospitalization. The hospitalization turns into maybe a rehabilitation in a skilled nursing facility. Eventually you end up back home, but not better necessarily.
Maybe perhaps readmission.
And then readmission. Yeah. And like I said, it's often described as that wheel that just keeps turning and turning and turning. And that's seems to be the case here.
And just from the background information that I was able to pick up, John, it appears that Mrs. Jones had maybe perhaps been a dialysis patient,
yep.
Maybe even prior to the stroke. That really kind of set off the chain of events here. So that's a part of her normal healthcare routine.
Yeah,
I think she already had in place.
Yep, and so yeah, in the last week or two, Mrs. Jones' healthcare had declined to the point where the hospital at least had her on a ventilator, essentially what most people would call a breathing machine for the layman term of that, and then also continuing to receive dialysis. But the family is happy with this treatment. They want the treatment to continue here, but the hospital has had a difference of opinion.
Right, and so apparently on May 3rd, the hospital, and this was a hospital in Houston, through their processes, provided notice to the family that they were going to be seeking to discontinue treatment, but that the family had was now the burden was now on the family to find a facility that would accept Mrs. Jones as a patient to continue her care, or else her current hospital provider would discontinue their service, their life-sustaining support services.
Yeah, and there's a this is all related back to the Advanced Directives Act, which when you read it, reads somewhat like a poorly written set of instructions. That kind of follows a step-by-step process. And I don't have it here in front of me, so I'm going basically off of memory, having looked at this thing about 8,000
yes.
times over the years. But really the first part of this is a determination by the treating physician that we have somebody who, and this is not a direct quote, but it's pretty close to it, has a terminal or irreversible condition that will cause death without life-sustaining procedures, or is in a persistent vegetative state, and if the treating physician makes that determination, then they're supposed to have another treating physician confirm that, and that's kind of step one. Does the person meet the definition of the statute?
Right. So clearly here in the Jones case, it appears that the medical providers through the hospital did in fact come to the conclusion, reviewing the definitions of the Advanced Directives Act, that Mrs. Jones was such a patient.
That's
that,
right.
Either permanent vegetative state or an irreversible and terminal condition, but they made that determination, and through the additional processes gave this family essentially what we call a 10-day notice, which is the notice to, hey, we're going to discontinue services here at this facility, and you've got 10 days to move your loved one to an accepting facility.
That's right. We'll get into that a little more here after our bottom of the hour news break. So for our radio listeners, stick around, and feel free in the meantime to check us out on the Facebook Live, where we'll keep talking. All right, clear from the live radio program, still live on Facebook. I have to say, I've been involved in issues related to the Advanced Directives Act a bunch over the years, but I would say it's almost predominantly been disputes between family members.
Right. Yeah, in the situations we've typically been involved in, it's been, one family member wants, perhaps even if their loved one has an advanced directive or a directive to physician living will, that, John, medicine can do so many things that are not listed specifically in those documents.
Well, and I know I had one particular case. This was one of the first ones I had, so it's probably 2 decades ago or coming up on it. But we had a World War II veteran who, following a stroke, had become what they call a silent aspirator. He was unconscious. He was non-communicative. So he was not responding to any sort of verbal cues, no nods, no anything like that. He was breathing on his own. His organs were functioning independently, but based on the stroke, it had essentially caused paralysis of the throat and the swallowing process, along with most of the rest of his body. But the silent aspirator part of that is that basically anything that you put in his mouth was able to go straight into his lungs, and not and yet, because of the paralysis, he would not cough or choke. So that's why that's where you get the silent aspirator part of it. And in any case, he had 2 daughters. These 2 daughters could not agree on the color of the sky under any circumstances. Right. And one felt like their dad would not want to continue to live in this sort of situation, and requested that no artificial nutrition be provided. And the other daughter thought that dying of a lack of nutrition was cruel, and that her father shouldn't be subjected to that. And in his particular case, he did in fact have a directive in place that, among other things, listed no artificial nutrition. It did take us presenting that to a local court, and we judge in that case ordered that no artificial nutrition be provided based on the guy's declaration. And that order then was provided to the medical providers, and he passed away about a week later. But that's where I often see it. Is either the spouse and the kids, or in between the kids, disagreeing. Now, I've had a number of them who have disagreed with hospitals, but often the situation has resolved itself relatively quickly.
Right. And so just like the Jones case, which, when we come back from our bottom of the hour break, we'll have a good 25 minutes to, for the rest of the hour to discuss this particular case and some developments recently with the Advanced Directives Act. We're fortunate in our community that we've not yet had a case that has pitted, a medical provider like a hospital against a family and their wishes. But John, I think that is just by circumstances. The reality is, I think even our small communities will start seeing these type of situations as the technology has gotten so helpful to assist and maintain life, and the economic pressures on our hospitals, medical providers intensify. I think we're going to see the same type of issue that is happening with the Jones family. We're going to see it in many communities.
Oh yeah, this is definitely coming around.
Yeah, and so there are some advocacy groups out there that are definitely pursuing assisting these families. The Texas Right to Life, and trying to get this law really a little more specific, a little more detailed. But it's about time for us to go back on it.
Oh, sure is. Here we go.
903-793-1071. Now back to Aging Insight with John and Lisa.
Welcome back to Aging Insight. This is your host, John Ross, here live in the studio with Lisa Schulmeyer. And today we're talking about the Texas Advanced Directives Act. And particularly some of the stuff that people don't necessarily realize is out there. People often think that whatever they want or whatever their family wants, particularly as it relates to end of life decisions or decisions that could end life, that that those would be honored.
Yeah, that those are personal choices. And as the Jones family down in Beaumont had found out, is on May 3rd of this year, their mother, who was receiving dialysis, was also on a ventilator. The hospital provided a notice, which is often called a 10-day notice. But the notice was provided to the family that said, "Hey, we're going to remove life support, or you've got 10 days to find another facility to accept your loved one." And John, I haven't spoken with the Jones family, but based on everything I've seen, this was definitely not the family's wishes. So, the family is saying, no, we want life support. We want this continuation. And the hospital, through their ethics committee, had issued this notice that said, nope, in 10 days, we're going to start removing, the life-sustaining treatments, and you need to move your loved one to a different facility.
Yeah. And this law was originally put in, I believe, in 1999.
Yeah, so it's been on the books for a while.
Yeah, it's been on the books for a while. This is not the first time that an issue like this has come up. But when they put the law in originally, one of the requirements in the law was that the state maintain a list of providers. The idea being that if you and your family have a differing treatment decision than what the hospital wants, like in this case, that when you're given this notice that, hey, we disagree, we think that the life continuing efforts of the hospital should be stopped, and the hospital saying, we're going to, you got 10 days to figure it out. That included in this is supposed to be access to a list of all of the medical providers that would take your person.
Yes, that would take the loved one, to take the patient. And John, I'm not familiar that there is any provider presently listed. I think there are providers that, on a case-by-case basis that
will consider it. I think the last time I looked at the list, there was one or two nonprofit organizations that didn't necessarily provide medical services, but would attempt to help.
Some advocacy.
I think there were a couple of attorneys on the list, but that was basically it.
Well, and in this case, so the Jones family was provided with this 10-day notice, and said, hey, you've got to get your loved one to another provider because we're going to discontinue. And in fact, the 10-day, John, can you imagine trying to navigate? Do you know how complicated the healthcare field is, especially when you've got a medically complicated patient?
Right.
And I did read an interview with Mr. Jones, who said, we're not wealthy people. There's a financial issue here, navigating through Medicaid payment, the financial support necessary. It's very, very difficult. 10 days is an extremely short amount of time to try to navigate through all this. And so that was the position the family was put in. And apparently, as promised, 10 days after the family was provided with this notice, the hospital did turn off and remove the ventilator.
That's right. Although in this case, as my understanding is, Mrs. Jones held on. She was able to breathe on her own without the assistance.
Yeah.
And essentially, when that did not end her life.
Yeah, with that, and I hate to be so blunt, but when turning off the ventilator didn't do her in, then basically the hospital says, or the provider say, well, we've also been providing dialysis.
Right. And, when people think about life support, I know when I'm talking to clients in the office and I talk about, let's talk about end of life decisions. And the response I always get is pull the plug.
Yeah.
And I think typically people have a tendency to think of the plug in this case as something like artificial nutrition, artificial hydration. What they don't often think about are some of the ancillary things like dialysis, which is a life-sustaining procedure if you're in a situation like this, and even things like antibiotics. If you get pneumonia, pneumonia is a life-ending disease, treatable with antibiotics. But and so if you're in a situation like Ms. Jones, and you have pneumonia, then all of a sudden antibiotics become life support.
Well, and I think on this case, what's interesting is that, from what I understand, is that Mrs. Jones had been receiving dialysis, prior to this hospitalization. So the dialysis itself was not a necessary add-on just for this most recent hospitalization and issue. That had been something that had been provided before. So then that raises a question in my mind, John, is, yes, it was clearly necessary for her to have dialysis, but that was not a life-sustaining procedure related to this current nexus, of health issues.
Right.
It was something that had been provided before. And so, is the hospital in any way right to withdraw that type of treatment that had already been a continuing type of treatment that she had received well before this threat to her life?
Yeah, and absent anything related to her specific wishes under those circumstances, we've got the family. In fact, that if you go through the statute and somebody doesn't have a written directive and they're unable to communicate it themselves, then it goes through a list of people who are supposed to be making these type of decisions, spouse and beyond that, kids and further family members. But you get down to the very bottom of the statute, and that's where it basically says, yeah, but regardless of all of that, if the hospital wants to go a different direction, they can go a different direction.
Now, and we were talking on the break that, yeah, the hospital can go a different direction. Now, John, this 10-day notice, sometimes people refer to it as a 10-day rule, which is kind of a misnomer. But, the hospital they don't have to give they don't have to decide, oh, we're just going to remove life-sustaining treatment. Here's your 10-day notice. There's nothing that makes the hospital do that.
No, it's just that once they make that decision, then it pushes the family to this very short time frame of 10 days.
Yeah.
But you're right. There's nothing on the outset that says the hospitals have to invoke this procedure. It's just that if they do,
then their steps have to be followed.
Yeah.
So
that's exactly right.
All right. Well, I guess let's take another break, and when we come back, we're going to talk about some of the monumental challenges that would be faced by a family and like the Joneses in this situation. And John, I think about it for myself when we start talking about all this. So come back and see us.
All right.
Listening to Aging Insight. Call 90.
All right. Well, we're still live. And yeah, according to Ms. Cook in the comments, there's no facilities, no medical facilities on the list.
That's what I
and
thought.
It's just organizations
and
attorneys. Yeah, I didn't want to say there weren't any at all because I
haven't checked today.
Yeah, because I didn't check, but I didn't think there were any. But I know when I looked at this years ago. And I was basically reading it for the first time, and I remember saying, "Oh, well, you're supposed to go and there's this list," and I pulled up the list and there wasn't anything.
Right, and we have trouble a lot of times finding nursing facilities that can manage events.
Well, and on that, I know, and we'll talk about it here on the show, but for anybody that's listening, Mrs. Jones has been transferred.
Yeah.
And presumably receiving care. Some of that's private, and so we don't even know about it. But I have read separately, like for example, in Texarkana, if you have an open trach.
Mm-hmm.
I don't think there's a facility in town that'll take an open trach.
There is not.
And being able to provide dialysis in a long-term care setting like this, that also specialty levels of care. And for somebody for a facility that can do both vent care and dialysis at the same time in a non-hospital setting, my understanding is that there were no, or maybe one or two facilities in the entire state of Texas. And there may not have been any. They may have had to go out of state. So, it is when you have extreme medical situations require extreme care, just finding access to it
right
can be extremely difficult.
Yeah, access, and then the financial piece. So,
and yeah, that's not even I think there actually used to be several more around the state that provided both of those simultaneously, vent care and dialysis at the same time. But that generally speaking, those were costing, according to the thing I read, was about $15,000 a month for that level of care. And of course, I'm not sure that Medicaid has a rug rate that would cover that level either. So even if you were on Medicaid benefits, I'm not sure it would help all that much.
Yeah, so we've got about 13 minutes left in our radio program today. So we'll get back on it.
Yep. Here we go. Maybe. All right, now we go.
Question, phone 903-793-1071. Now back to Aging Insight with John and Lisa.
All right, everyone. Welcome back to Aging Insight. I'm Lisa Scholmeyer, and I'm here with John Ross with the Ross and Scholmeyer Elder Law Firm. We bring Aging Insight to you every Saturday to just inform you and educate you about what is going on. We became aware of the Jones case, last week, and we really kind of been following that a bit. Wanted to bring that to you, John. We were kind of talking about difficulty of access to care, and here, when a patient's family receives a 10-day notice, when a medical provider decides on their own and against the family's wishes that they're going to discontinue medical support for this patient, and then you've got 10 days to find a transfer. John, it's not just about finding a place, and we talked about how difficult that can be. It also is about coordinating the continuation of care, the discharge, the acceptance. And John, I just think about how difficult it is working with some of our families when there's a discharge from an acute care hospital to a skilled nursing facility.
Well, I mean, we just ran into it a week or two ago with somebody that was being discharged basically immediately from a behavioral health unit with no way really to get that person. There was no other facility that was willing to take them at the moment, and
So I can only imagine the red tape of in this situation. Looks like we have a caller to our show, so we will bring in the caller if we can hit all the right buttons. All right, caller, you're on Aging Insight. Yes. Yeah, so yeah, the caller is saying that we're having so many developments in the artificial intelligence realm that perhaps in the future to keep the individual people out of the decision-making process, that perhaps someone who's medically difficult, or with those decisions be turned over to an AI type of decision maker, so no human person would be involved in that decision. That's certainly an interesting idea. So
yeah, well, luckily that hasn't happened yet.
Yeah, so but the caller, and thank you, caller, very much for that comment. And that certainly came out in an election cycle or two ago with the idea of what they call death panels, which would be like bureaucrats that were not elected that would decide which medical procedures would be available and how many of those would be funded. And that was the whole protest to that idea, was that you would insulate decision makers from the political process.
But interestingly enough, I mean, that's basically what this is.
Yeah, because you have an ethics committee through the provider. So it's not a state actor making a decision to go against a family's wishes and withdraw life support treatment. It's a hospital, which is a private actor, but they're using the tools given to them by the state through the Texas Advanced Directives Act to push this family to that point.
Yeah.
So
a couple of things real quick on this, and then for a couple of things for y'all to think about out there. The first problem we have with issues like this, there are some really good legal arguments that this whole thing is messed up. That it violates due process,
it's unconstitutional.
that it's unconstitutional, and several other things. The problem we have in Texas specifically is an issue that in legal terms is referred to as mootness.
Yes, that just means that a case where these issues are relevant, it becomes moot before a court can ever hear it because the patient dies. That's
right. And so basically what the court is saying is, well, this case involved whether or not to keep this person on life-sustaining treatment.
Whether the procedure in the statute was constitutional.
Right.
But we don't have to talk about that because the person's already deceased.
That's right. And that has happened. That issue has already happened in Texas on this same issue with a young man who was in a similar circumstance. And the court, because the way Texas law reads, the courts are able to basically dodge this whole issue just so long as the person involved passes away before they ever get to a decision-making point.
Well, and of course, all of our listeners out there certainly know that they've gotten the idea that the legal system does not move quickly. Even when it moves quickly, it's not that quick. And so I know there are lots of advocacy groups that are trying to get this issue before courts and making the argument that, look, this situation is going to come up over and over and over again. Yes, court, every specific situation that raises these issues may become moot before the court can hear it because perhaps the patient passed away, but there'll be another case next week and another case the week after that. And so the court needs to hear these challenges to the procedures that are employed under this law, so that way we can refine them and make them better and not just keep ignoring it.
Yep. That's one thing that's going on there. And there's you as a person listening to the show, there's not much you can do to influence that's more of a court construction issue. There could be legislation on it, but that's really not the main issue. The main thing right now is, as it relates specifically to this issue, Senator Brian Hughes,
Whoop, whoop.
Your former classmate?
Yes, my former classmate from Baylor School of Law. And Brian Hughes is actually the state senator that represents the district that we are broadcasting from. And that is the East Texas district. So tell us what Senator Hughes has done. So
he sponsored Senate Bill 2089. This is supposed to help rectify some of these issues. I pulled up the text on it, and basically that this would put some burdens on the ethics committee by, one, preventing them from considering any of the financial or professional conflicts of interest. So in making these decisions, so they can't look at this situation and go, it's too expensive.
Right, and that has been something that a lot of my families have brought up, John, that hospitals and medical providers would make decisions based on the cost.
Right, and so this would prevent them from considering that, and also prevent them from consideration of the patient's permanent physical or mental disabilities during the review unless that disability is specifically relevant in determining whether a medical or surgical intervention is medically appropriate.
Now that is a mouthful, John.
That was a mouthful, and I'm reading this off the Legiscan from the bill text. So
yeah, I'm not sure exactly what the second provision is meant to address. Perhaps I'm thinking about Mrs. Jones here, who was already receiving dialysis. And perhaps that means that the ethics committees cannot consider her maybe pre-existing disabilities or conditions, or because that really wasn't relevant to their issue with her current life.
Well, and particularly when we're talking about some of the things that we see, we deal a lot with dementias, and as it relates to things like dementia, where they're saying, look, that dementia doesn't have any issue necessarily related to what their current status is.
Yeah, because I hear a lot of times from people that that say, well, that patient has dementia anyway, so what kind of quality of life is that? So we shouldn't intervene with expensive medical interventions because even if we can fix her heart, the dementia is still there, and so perhaps they're kind of looking at that situation.
Yeah, so that's now all of that to say, as we kind of roll up here towards the end of the program, this still doesn't change my opinion that you should get your own wishes in writing in advance.
Absolutely.
Whatever those wishes are. There's some things that there's some wishes that are prohibited by statute. For example, you cannot have an advance directive that would terminate life support if you were pregnant, period. Yeah. So even if you said that, it's not going to happen. That's prohibited by statute. You cannot, in the state of Texas, you can't put in your advance directive that you want to be euthanized. Also not allowed. But sit down with your physicians, talk to your friends, talk to your family, but go through some of these scenarios and say, if you were in this situation, what would you want? Talk to your family about it, and then ultimately get that sort of stuff in writing. And again, this is not just as simple as pulling up a form off the internet. Texas has some statutory forms for this, for the advance directive, for medical power of attorney. They're not very good. They're not very thorough. They don't get into the kind of the nuts and bolts of what is and what is not life-sustaining treatment, and in what situation you might want to be in. I've talked to everybody under the sun about this stuff, and I've seen a wide range of opinions from people.
Yeah, that's right. And also you need to take into consideration, if you already have some chronic health conditions, do you want those to continue to be treated? And this is very personal for each individual. So
that's right. Well,
and I want to say thank you to Ms. Cook for her comments today.
Yeah, thanks for watching the show. We appreciate it. Feel free to reach out to us if you've got any other questions, or if there's anything we can do to help. And best wishes to the Carolyn Jones's family under these very trying circumstances. I hate anybody that has to go through anything like this. I mean, it's bad enough with the medical condition. When law kicks you in the butt on top of it, that's just awful. So anyway, hope everybody has a good time out there, and we will see y'all on next Saturday's show. Have a good one.
John Ross and Lisa Schulman.
And thanks to all of y'all for watching. And again, thanks for commenting and getting in touch with us earlier, Mrs. Cook. Appreciate it.
Yeah, thanks.
We'll see y'all next time.